My lord, may I allowed to mention a matter? My lord, it is regarding KMDA matter. It is that I have challenged the imposition of penal charges on me for delay in construction of building. My lord, the KMD has introduced a new policy under which
What do you want?
I want inclusion in the my urgency.
Pushan.
No, my lord, hearing. My lord, there is an urgency. I don't want to go into the merits of the matter. KMD introduced a new policy that if I pay only 10% of the penal charges on IGR valuation, they will provide extension for another 3 years.
It cannot be added prior to the vacation, only 8 nights. Please mention after the vacation.
And I have particular mention on the correction of the order.
Yes. Yes, call the list. You mentioned the
Number one.
Mr. Mujumdar, have you seen that?
It appears that they have approved.
We have approved. No.
Please.
They have said
In the second page. Please simulate the second paragraph of that letter.
second paragraph of the letter.
Yes, 28 January 2026. On the first page.
No, the letter or the report.
The instruction.
Instruction. Second paragraph.
Yes, in the first page, paragraph II.
Yes.
As per OM dated 30th September 2008, Department of Expenditure had conveyed about extension of recommendation of the 6th CPC to the employees of ABs. Oh, I'm sorry. No, there's a previous one.
Yes.
4th May 2026. Please see the 4th May 2026. But please see second paragraph. The question number 3 in the said RTI was whether DST allowed the 6th CPC benefit to the AIs under it including ISES. A related question number 4 was whether DST took approval of DOE for serial number 3 above. In reply dated 5th October 2021, yes was replied to these questions. In this regard, it will be mentioned that as per OM dated 30th September 2008, Department of Expenditure had conveyed about extension of recommendation of the 6th CPC to the employees of ABs, whose pattern of emolument structure is identical to those of the central government employees, subject to certain stipulations. The said OM provides for constitution of group of officers and concurrence to its recommendations in case of those categories of employees whose pattern of emoluments are not similar to those of the central government employees. This ministry, that is Department of Science and Technology,
yes,
while later dated 3rd of October 2008 had forwarded the said OM to AIs, conveying that the instructions contained therein are brought to the notice of all concerned for immediate compliance. The institutions which desire to adopt the CCS RP rules, that is Revision of Pay Rules 2008, may do so after issue of these instructions, and certain conditions should be kept in mind while fixing the pay in the revised pay structure. So, when the pay revision is admitted, fixation of pay is with the appropriate authorities or the appropriate employers, because not pay revision committee never fixes pay. The concerned file in which the said letter dated 3rd October 2008 was issued is not traceable despite best efforts. However, it seems that the RTI had replied yes to those questions considering Department of Expenditure's OM dated 30th September 2008 as the approval for extending 6th CPC on ISES.
Thereafter, paragraph.
Please see. However, it may be reiterated that the ministry, while later dated 3rd October 2008, had forwarded the Department of Expenditure OM dated 30th September 2008 to AIs. That is,
what is AIs?
Autonomous institutions.
Autonomous institutions, yes.
Mentioning that pay fixation in the revised pay structure was subject to the provisions contained in Department of Expenditure OM dated 30th September 2008. But I pause here for a moment.
Yes.
But what the pay commission does, it only revises scales and confers benefit. It does not fix pay. So pay fixation is left to institutes, autonomous institutions.
Yes.
One of the conditions stipulated in the Department of Expenditure OM was that final package of benefits proposed to be extended to the ABs, that is autonomous bodies, is not more beneficial than that admissible to the corresponding categories of the central government employees. not its financial package. However, the group of officers constituted subsequent to the 7th CPC found that the employees of ISES are in receipt of higher pay and allowances than that admissible to the corresponding categories of the central government employees, and recommended steps for restoring the pay and allowances to their original position as on 21st December 2005, and grant of telescopic or retrospective fixation and disbursement as per 6th CPC and 7th CPC recommendations. This paragraph is completely beyond a reference to the pay commission. Implementation of 6th CPC does not give blanket approval for irregularities concerning promotion. Promotion upgradation is something else.
Yes.
Now today, what is a reference to the pay commission? It revises the pay and decides on the benefits. It does not fix pay. That's where the ministry is going wrong again and again. Not this 4th May 2026, not this instruction or not the expression of mind of the ministry. Not now things bring things clear. There was no occasion for the pay commission at all. But a pay commission only revises the pay structure. It does not fix a pay. Fixation of pay is personal. A pay commission never fixes personal pay. Today, when the 8th pay commission will be implemented, will the personal pay of the employees be regulated by the pay commission? No. They will only decide what will be the revision of the pay, the structure, what will be the quantum of pension, what will be the quantum of DA or HRA, other allowances, etc. Fixation of pay with allowances is personal to an employee, whereas pay revision is en bloc. That's where the ministry is going wrong again and again. Not several employees in the same organization will have different pay depending on their seniority or not the date of entry into a particular grade.
So finding in the judgment under
Yes, not your lordship had only partly allowed our claim and partly.
I think I said that the approval that's one.
Yes, that's the only ground on which not this was.
Yes, please show me that.
29.
Please come to the review application.
Yes, you can refer to the
Yes,
paragraph.
please come to paragraph 33.
33.
My lord. 33, 37 and 39. These are the 3 paragraphs.
Yes, 33.
It is not the case of the petitioner herein that he is presently not in receipt of higher pay and allowance than that admissible to the corresponding categories of the central government employees. The OM dated September 30, 2008 also provides that the final package recommended by the group of officers will require the concurrence of the Ministry of Finance of the Department of Personnel and Training, as the case may be. But this is probably where the ministry has now come up with clear hand. Therefore, unless the final package recommended by the group of officers in respect of the 6th CPC pay scale has been approved by the Ministry of Finance, mere extension of benefit of 6th CPC pay scale by an autonomous organization like ISES to its employees cannot confer any right upon such employees to claim 6th CPC pay scale as a condition of service. But this 6th CPC pay scale has been approved by the Ministry of Finance. What is regulatory is while fixing the pay, you don't give more benefits than central.
Approved according to you by later dated 3rd of October 2008.
Not pay scale approval granted.
Yes, that is by 3rd of October 2008.
That's the pay revision. But what was that revision of pay rules for the central government employees? This 4th May 2008 letter also says so. CCS revision of pay rules 2008. Now please come to paragraph 37.
Yes.
As observed hereinafter, the group of officers was constituted for the autonomous organizations where the pattern of emolument structure is not similar to that of the central government employees. The said committee made certain recommendations to contain overpayments to the employees of ISES. The learned counsel for the petitioner could not satisfy this court that such recommendations were made on extraneous consideration. In view thereof, the recommendations of group of officers do not call for any interference. Central government issued memoranda for extension of the benefits of 6th and 7th CPC pay scale to the employees. of autonomous organizations on certain conditions. Such being policy decisions, this court is not inclined to interfere with such decisions, but I don't stand on that. Paragraph 39. No document has been produced before this court to show that the final package recommended by the group of officers for extension of the benefits of 6th CPC pay scale to the employees of ISES has been approved by the Ministry of
So
Finance.
approval was wanting on that ground.
Approval of pay revision was granted by the Ministry of Finance. It now appears.
Yes. So at that point of time, no document was produced to show that that approval was granted.
So not the pay revision implementation was approved by the Ministry of Finance. Not I, although not very necessary, but not for the rules. Rules cabinet rules. But there is a cabinet secretariat rules framed, namely the Government of India Transaction of Business Rules 1961.
Yes.
Not. Please come to paragraph 4
Paragraph 4
of that order.
Yes. Interdepartment.
Yes, interdepartment considerations. When the subject of a case concerns more than one department, has your lordship got that?
Yes, yes.
No decision be taken or order issued until all such departments have concurred, or failing such concurrence, a decision thereon has been taken by or under the authority of the cabinet. Explanation. Every case in which a decision, if taken by one department, is likely to affect the transaction of business allotted to another department, shall be deemed to be a case the subject of which concerns more than one department, unless the case is fully covered by powers to sanction expenditure or to appropriate or reappropriate funds conferred by any general or special orders by the Ministry of Finance. No department shall, without the previous concurrence of the Ministry of Finance, issue any orders which may, please come to the last one, otherwise have a, on that page, D, otherwise have a financial bearing whether involving expenditure or not. Please turn over to the next page. Provided that no orders of the nature specified in clause C shall be issued in respect of the Ministry of Finance without the previous concurrence of the Department of Personnel and Training. So, not for the Ministry of Finance, it is DOPT. For other administrative departments, it is the Ministry of Finance. But when it involves an expenditure, two departments have to be consulted. Once the ministry, through either limbs, through either of the two limbs, has admitted the fact as a proposition of fact that the administrative guidance of this Ministry of Science and Technology had the approval of the Ministry of Finance in so far as revision of pay and allowances, that is ROPA, is concerned, then there can be no second thought in this aspect. At the time of implementation of 7th CPC, why should you go back to the 6th CPC?
Yes. Anything more, Mr.
No, this is
Lordship, I am only coming on the page, our written instruction. C. Implementation of the 6th CPC does not give blanket approval for the irregularities concerning promotion and upgradation.
That's different. He is not paying for promotion and upgradations.
Upgradation,
Here,
upgradation not for the job, upgradation for the other irregularities of the salaries.
upgradation of
This
pay.
is our meaning. Because
But upgradation of pay is
later dated
MACP.
3rd of October 2008. Please show me that. 3rd of October 2008.
a group of officers has
172.
170. Annexure 4. No, here you have not had
Read petition page 172A.
page 4. Petition is not here. Do you have a copy of that?
Yes, yes, please have a
আছে?
look.
Of that, Mr.
But it's heavily marked, but please have a look at this.
এটার মধ্যে দাও।
এটা তলায় 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 একদম লাস্টে আছে দেখো মোটা পিটিশন একদম আরো লাস্টে এই যে এইটা ছিল পিটিশন
Subject is pay revision of employees
72
of quasi-government organizations, autonomous organizations, and so. I am directed to forward herewith a copy of OM dated 30th September 2008 on the subject cited above. And
This is issued by whom?
this is issued by
Deputy Secretary to the Government of India. Sir, এখানে
Which department?
kindly have a look into the bottom
These are not visible, very eligible to.
Department of Expenditure.
Please,
Department of Expenditure.
আরে 3rd অক্টোবরটা বলছি।
2008. It's issued by which department? Not very
But
legible.
Lordship may kindly come to the main one, the next page 172A.
Ministry of Science and Technology.
Oh, this is issued by Ministry of Science and Technology.
30th of September 2000.
Yes, not 3rd October 2008 is by Ministry of Science.
Where do you get
But
that?
it's not very happily legible, but there is a better copy not here.
So it's by Ministry of Science.
Science and Technology.
My lord, it
Not
has
by
been,
the
it has been given by, it has been given by the DST to us, that later instruction
Yes,
as
this
well as the
ministry has
annexures.
Forwarded this OM to.
I'm giving a copy of it to the, with all the annexures. This has been given by the Ministry of DST.
কপিটা আছে তো? হ্যাঁ হ্যাঁ
এটা না, একটা কপি দিয়েছিল এই দেখো। কপি
হ্যাঁ হ্যাঁ
আমি দিই না।
এর সঙ্গে সব
সঙ্গে সবকটা অ্যাটাচ করে
annexure গুলো অ্যাটাচ করা আছে।
অ্যাটাচের মধ্যে তাদের প্রবলেম না হয়।
Email এ পাঠিয়েছি।
Government Ministry of Science and Technology.
30th of September is a different. It says that conveys extension conditional,
Yes.
whose pattern of emolument structure is identical to those subject to certain
Right.
stipulations. And that was forwarded by 3rd of October, that memo.
That's the
But where is that approval, that letter? So the RTI reply says, but the approval, where is it?
not approval, not may I put it in this way? Not a pay commission recommends pay scales. Not there may be different pay scales for different bodies. So this is for all autonomous institutions under the Department of Science. So there is a pay scale which is approved by the pay commission, which ultimately has the sanction of the Department of Expenditure through the Ministry of Finance through the Department of Expenditure.
Because
Now this guideline is for fixation of pay, which is different from pay revision. But I might have been drawing, say,
I follow that, but only the ground in the judgment and the review, that was, it says 30th of September was taken note of.
yes.
Thereafter, it says that the OM data provides the final package recommended by the group of officers will require the concurrence of the Ministry of Finance. So that memo also said it requires the concurrence of the Ministry of
Yes.
Finance. Where is that concurrence?
Not please,
Except that reply, there is no document.
not group of officers constituted for the purpose of inspecting as to whether employees of a particular autonomous institution is getting higher pay in
Yes.
comparison to central government employees in the corresponding job. But that is for the purpose of pay. Now, not at the time, this 7th, why did we approach this court? 7th pay commission's implementation was deferred. Unless this pay was reduced. But pay is personal to this employee. Once the Ministry of Expenditure has, or the Ministry of Finance has approved the pay scale for autonomous bodies, why should you not implement?
Solid. And you are relying upon only the last paragraph of
Lordship,
that.
Lordship.
But this promotion and upgradation only for the purpose of clarification. This upgradation is for, say, MACP or a financial upgradation for stagnation, like that.
30th of October is at page
172 and 30th September is 172A.
30th September is page
172A.
172 capital A, and October is 172 only.
Yes, Lord Lordship may have a better copy, not in that. It has been
Can I
handed.
give only a copy of it?
There is a copy handed.
ঠিক আছে।
My lord, this has been given by the, with the instruction, the annexure they have given to us. Where the DST, as per number 3.
30th of September is there, 30th of
Oh, both are there. my
Both are-
30th of October is not here.
3rd October.
3rd October, sorry.
Last time.
3rd October is
3rd October is also
also
here.
there.
So in the bunch of documents,
No, this has been given on instruction. Unfortunately, my learned brother has got the instructions only. But
in my copy you have not given.
No,
Part of-
Only that copy was missing.
Missing.
that copy they have not
Please,
written.
please come to internal page 2 of the 30th September 2008 letter. Internal page
Yes.
2,
Is Mr.
paragraph 4.
Yes.
The adoption of revised pay structure based on these orders by the autonomous organizations, etc., both where the pattern of emolument structure is identical to central government and where emolument structure is not similar, will be subject to the following conditions as far as budgetary support for additional expenditure is concerned. A, 80% of the additionality will be made by the central government, 10% of the additionality will be made by the autonomous organizations through additional generation of revenue, and balance 10% of the additionality will be managed by the autonomous organizations through savings. In the case of autonomous organizations, etc., which have no source of generating revenue, 90% of the additional expenditure will be made by the central government. If the additional expenditure cannot be made in accordance with the funding pattern mentioned in paragraph 4 and 4.1 above, each request for funds in excess of the amount worked out as per this formula will be examined on merits by the administrative ministry and sent to this department for consideration. So, paragraph 4 capsulates two situations where the pay is in alignment with the central government employees, and number 2 where the pay is not in alignment with the central government employees.
All right. Mr. Mujumdar.
রুলের একটা কপি রুল দিস রুল
Yes.
Mr. Roy requested me to hand over before your lordship. He has found out a new judgment.
Where is he?
But he's engaged before courtroom number 6. But he requested me rather that I should hand over, my lord. This 85 to CHN, my lord, it's the same line of the other two judgments of Justice Banerjee.
Chandro's judgment, Chief
Yes.
Justice.
My lord, that, my lord. And my lord, Justice Bhaskar Bhattacharya's judgment, my lord, Ashima Datta, paragraph 11, Mr. Roy is relying upon, I am relying upon paragraph 15. But in my copy, my lord, that's from SCC online.
SCC, please give the SCC online.
SCC online.
To take this.
I have
That.
I can give you.
আচ্ছা এখান থেকে আছে তাহলে ঠিক আছে I have another copy দর্শককে দিন আমি এখান থেকে করে দিচ্ছি
Oh, this is Supreme Court. Do you have SCC online copy?
but that's not printed since Mr. Roy said that he is going to rely upon
Yes, yes. Mr. Roy is relying upon which paragraph?
paragraph 11.
So that was Mr. Dasgupta's submission.
Yes, I am relying upon plot paragraph 15. That's the finding of the honorable court.
How does this judgment help either of you?
Where I am on, it's not about the right of the preemptor should exist at
Here
the
is
time
the
of filing
case,
of the application.
If I recollect the facts, here was a case where there was an earlier transfer.
Not preempted.
Now, earlier transfer was not challenged. But the second transaction was challenged. By virtue of the earlier transfer, he became the co-sharer.
But until and unless limitation
He
expires,
became the,
yes,
he became the co-sharer.
absolutely.
He can resist. That was the fact of
Absolutely.
Fatibad also.
I'm only on
So
this.
that
I'm
cannot
only
be
on this. Justice Bhattacharya, my lord, at the time of my lord delivering this judgment, I have laid down the law that it's the preemptor, his right of my lord preemption. It's not only exist at the time of filing of the application, but it should remains continued till the grant.
settled.
Yes.
So it's not that
No, no.
like reasonable requirement.
Yes,
Till the
yes.
passing of the decree,
Absolutely.
you have to
My lord, I am handing over, my lord, the sub silentio judgment, paragraph 11, my lord, I have relied upon. Lord, I will just conclude my argument since Lord, the new judgment Mr. Roy has cited.
the Oshima Datta, Mr. Rai was citing for what? He was citing for what? Where is he?
Lord, Lord, only one thing, Lord, may I just canvass before your lordship. Since, Lord, three of the coordinate bank judgment of your lordship's court, apart from sub silentio, whatever I have distinguished, just Lord takes up section 9.2 once for my satisfaction. Because this example I have not Lord given before your lordship. I will take my interpretation of Lord this provision as well as Mr. Roy's interpretation.
Inform sector কোথায়?
হ্যাঁ, তুমি রাখো দিন তোমার কাছে। আর লাগবে, আমি তো দিয়ে দিয়েছি দর্শক। Section 2, according to Mr. Roy, if on the day of filing of the application, his preemption application is maintainable, then whatever subsequent transfer that is subject to the application of first preemption. That is Mr. Roy's interpretation. Let us read the provision. When any person acquires the right, title, and interest of a transferee in such plot of land by succession or otherwise, though it can be testated succession or intestate succession. It's both, or otherwise means any mode of transfer. If a third person acquires right from the transferee, I will give two examples of this. Suppose, my wife, I am the preemptee. I am a stranger purchaser in respect of plot X. Preemptor filed an application for preemption against me since I am a stranger purchaser in respect of plot X. I dies. My wife was a co-sharer in respect of plot X. So automatically, it's a intestate succession. The property is being inherited by my wife. According to Mr. Roy, even then, the preemption application will be maintainable and continue. That's not the interpretation of the section 9.2. Otherwise, the last part of 9.2 will become nugatory because the language starts with when any person acquires the right, title, and interest in the of the transferee in such plot of land
Yes,
by succession,
the right to come.
by succession or otherwise. Milord, this takes care of both these things. That's why Supreme Court has interpreted that yes, it can be in both ways. But according to Mr. Roy's submission, even if that happens, then also a previous my wife who is a co-sharer in respect of that property, if he steps into the shoes of mine, automatically 9.2 will come into effect. And 8.1, again the avenue compartment will open. And since my wife will fit in the first compartment as a co-sharer, so both of them will be of equal degree. According to me, there, this submission or rather interpretation of this provision.
Submission is in by taking the aid of 58 Supreme Court.
I am
because
taking aid, my lord, but
you are saying that if that devolves upon a co-sharer, standing equal right, stand on the same footing. As
then
that
9.2 also, my lord, takes care of this. 9.2, my lord, this honorable court interpreted in such a way that whatever transfer, whatever way, once the preemption application is filed in respect of first transaction, it will continue. It's not that. It's not the intention of the legislature. Had it been so, then this intested word or succession word is
Why
not
you
being
have let
involved.
Mr. Mukherjee in this, now he is arguing on new points.
New points?
Yes.
Because my lord, Mr. Roy has invited me
No.
by my lord
What
showing this
time
judge.
to?
Left him with the judgment.
I
Still to rely upon
আমাদের মধ্যে ঝগড়া লাগিয়েছে।
now
On-
he is reopening the entire thing.
No, Milad, it's something, Milad. I rather read.
Start afresh from 9 to.
Yes, yes. According to me, Milad, the submission of Mr. Roy, or rather the interpretation that has been.
Underestimated him.
No, never. That was trust I had that he will not mislead the court or not make any submissions is contrary to law. That much confidence I had.
Thank you. Milad, according to me, this interpretation that is being provided, Mr. Roy, with regard to section 9.2.
The example
Yes.
in front of Mr. Roy.
Today, Milad, this may I read the statute at the after. When any person acquires the right, title, and interest.
No, no.
Dealing. Yes, take it.
The 9.2 doubles. When any person acquires the right, title, and interest of the transferee in such plot of land by succession or otherwise. The second part I am not reading, Mr. Roy. Now, suppose I am giving an example. A suit is being filed for preemption against me in respect of X plot of land, where I am a stranger purchaser. So, the preemption is very much maintainable. Now, I died. My property is being inherited by my daughter. Sorry, by my wife. My wife was a co-sharer previously, was a co-sharer in respect of plot X. So, if this happenings happened in respect of the property in question, then according to the interpretation as provided by Mr. Roy, even then the preemption application is very much maintainable, even if my wife is a previous co-sharer in respect of plot X. But according to me, the provision of the subsection 2 takes care of both these things. It's succession, either intestate or tested, and or otherwise any mode of transfer. And my interpretation, if your lordship keeps in on your lordship's mind, then the legislature intention was that then again reopening of section 8. Why? Because if after succession it is found that yes, my wife, since a previous co-sharer, again if section 8 reopens, my wife will fit in one of the compartment. Then if again section 8 reopens, then my wife become a equal status than that of the preemptor. So there will be no question of any higher right. So automatically the preemption goes. That takes care of AIR 1958 Supreme Court.
Or
That
in other way, you are giving the example of intestate succession. So in that example, it can be that the preemptee also to frustrate can transfer. By way of a
yes,
by way of a
Gift.
gift to the wife. So then also the earlier one goes, he has to file a second one. Second one also the transaction is exempted one. Secondly, your wife is a co-sharer on both grounds.
And Oshima
will not
Datta
be-
says that this right has to coexist till the grant of preemption, as your lordship said, as in a case of reasonable requirement. So there can be devolution, there can be transfer. So this succession, by this mode also, if we interpret 9.2 in a way, I interpreted, or rather Supreme Court interpreted, that will give a meaningful interpretation. But according to Mr. Roy's interpretation, if this judgment, this provision is being interpreted that whatever transaction, whatever transfer, whatever devolution of interest, tested or intested, once the preemption application filed and on the day of filing of the preemption, if it is found that he is a stranger purchaser or a lower degree, then automatically it percolates down. But that is not in my respectful submission, the provision of law.
May I get back little? I handed only one copy to your
Judgment.
85 to CH.
85 to CHN is Justice Satish Chandra, Chief Justice's judgment.
I'm not 53 CWN.
7 CWN to
53 CWN is the judgment.
6F.
53 CWN is a judgment where the initial transfer to be considered for the starting of preemption. Every subsequent transfer is subject to the
Transfers, all the subsequent need not be challenged.
challenge.
If first is challenged,
All subsequent will be subject to. So, irrespective of which transfer is made, and there, my lord, it is not that it is transferred to what Mr.
Yes, yes.
Original co-sharer. That was also held because
against me. That's why I have
No, no,
not
no.
distinguished that.
I have not said that. The argument that is
Actually, it is not against that.
53 was by the single bench, 57 by the
this
division.
division bench.
So it and the bench, the author of the judgment of the division bench, author
Yes.
the judgment is the single bench.
So, সব দেখে নিয়েছে? And my lord, why I relied on Oshima Datta, because if a Lordship Ali considers paragraph 11, because paragraph 11 of Oshima Datta, your Lordship will find Mr. Dasgupta's argument was that he has right to preempt the second transaction between the same parties. Now, that was taken care of by paragraph 50. Different.
That is why I asked you, why are you?
No, only for that purpose, paragraph 11, that each transaction is subject to right of preemption. And if that preemption applied, then such transaction, subsequent transaction is subject to that right. But it is not necessary after 85 to CH. My lord, I have had it over to your lordship.
There is, Mr. Rai, there is a distinction here. The argument at paragraph 11. When the first transaction was made,
There is no application for preemption. His right has been perfected as a co-sharer.
you will have a right to preempt.
He did not exercise.
Limitation expired.
That is subject to a period of limitation.
Yes.
So within that period,
I could have applied for, then I entitled to get second.
period expires.
Yes. Then my
So his
perfect.
right of co-sharership,
That's perfect.
so the right of preemption stands excluded thereafter.
Yes.
And
So-
my status elevated as a co-sharer.
He gets an exclusive right as a co-sharer.
Yes.
Now, he transfers. Or the transfer when it is being made to him.
Then he is a co-sharer.
Yes. So then if you resist, you cannot resist. You
In
cannot
ab-
say yes, by virtue of the first transfer you have
transaction.
become, that's the
That is 50. That is why my lord, I draw.
this does not fit in with your case.
No, after 80, that is why I have said, my lord, after 85 to CH, my lord, I have not.
Because even in a case where prior to filing of the preemption application, the
Transfer has been effected.
conveyance was made.
3 months within the period of limitation, because that transfer is subject to limitation.
Filing,
Yes,
then also this-
that transaction is subject to limitation of filing of preemption.
Always.
So therefore, even if transfer, the initial transfer is subject to limitation, and I exercise that right within the period of limitation. The subsequent transfer, though it was made prior to filing of
if you even if it is within time, you did not file, even then we will have a right. The question is
Yes.
whether
That right will continue till the
yes,
period. Thereafter, his right got
So,
perfect.
starting point there is no dispute.
dispute.
end
So,
point.
End point.
End
Yes.
point.
Yes.
Now, the end point is one thing which is to be considered. And what do you say, three coordinate bench decision taking different views?
But I will only, my lord, request your lordship, decide it, my lord, whatever way. Do not
Take
send
that
us
to
my lord, to
larger
it's,
way.
it's something, my lord. Now we have given, my lord, your lordship, my lord. If your lordship is with
Because the judgment of the coordinate bench which you relied upon did not consider
Also, the earlier judgment, I am not on that. My lord, whatever, my lord,
the earlier judgment.
53.
No provi-
Milord, the Justice Tandon.
No, that's Justice Tandon.
Yes.
Milord, but it's
No
contrary
judgment.
to that. Earlier decision says no.
No, very well, Milord. I have given your lordship, if my
All
interpretation
the
is
ammunition
your
to
lordship.
my lord to fire against us, but whatever fire you, my lord, wants to make, but don't send us anywhere else.
In any way, Milord, if your lordship is
Sure.
with me with regard to interpretation, Honorable Supreme Court has interpreted.
Yes.
And in none of the judgments,
And 58.
I can take
No.
with greatest of responsibility.
So much that I'm getting respect to my learned friend, not say friend, that 58 Supreme Court has been considered in 85.
Considered
Yes.
How?
85 to CHN.
Yes. আছে তোর কাছে একটু দে তো
নিয়ে তো পাঠিয়েছিল।
Yes. হ্যাঁ পাঠিয়েছিলাম তোকে তুই দে একটু আমাকে আমার কাছে ছোট হ্যাঁ 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 দে কি দিচ্ছি?
I
54
Not get that.
Yeah.
I must have missed it.
No.
না না 54 Supreme Court
58 Supreme Court, that's why I say
54 Supreme Court
greatest of
No, 54 and 58. There's a distinction.
yes
have seen.
54 is by a larger quorum.
yes
58
this is a
is by
lesser
a
quorum
smaller quorum.
54 was considered
Some homework.
হ্যাঁ তা ভালো
So,
তো
54 is by a larger quorum. It says the right of preemption goes with the land. It's not a right of personal. That's and 58 Supreme Court takes a different view. 58 Supreme Court offer this. 54 says different thing. It's by a larger quorum.
it is ruled that the right of preemption attached to
By
the
a larger
property
quorum.
But
Do you have 54?
এখানে রেফার করা it is referred 54
Not
Nah.
referred in,
Ultimately,
as
Milord,
only-
it is runs with the property
it comes down.
it runs with the property
Yes.
It comes
But
down.
see, 58.
runs with the transaction
Yes.
If 9(2) is being interpreted in such a way, then my whatever example lastly I gave, it becomes nugatory. If this interpretation it comes to the land, my wife who's an independent.
Interpret 9-2 in my own way.
চলো
That-
এই তো এই ছেড়ে দরকার পাঠিও না কোথাও enough we have exhausted us after a long time
Relevant provision, none of you have referred.
কি হবে
সেটা তো ভালো তো।
সেটা আরো ভালো because
Something new will come up.
I do not know go in which way, but
that is immaterial
that's none of you have referred to
কোনটা
that.
আর পড়ো না। Ask Milord insisted tutorial.
পড়াশোনা ভুলে গেছি পড়তে
অনেকদিন পরে করলাম।
অনেকদিন পরে পড়াশোনা করেছি after long days we have gone to research work
এত incomplete.
now
Yes.
For the respondent lordship, I am for the petitioner, my lord. In this case, my lord, I am not facing this because, my lord, my
Instructions you have got.
yes, my lord.
The last instructions. The instructions is to
In that case, my lord,
nothing with regard to those settlement and other thing, nothing has been said.
in that case, my lord, my prayer is only, my lord, consideration of representation, my lord. That should be maybe considered, my lord.
Did your client sign in front of you?
No, that is sent by the advocate conducting lower court.
Conducting advocate, where is he?
My lord, in the lower court, my lord.
Are you sure the petitioner signed this?
He sent me my to WhatsApp, my lord.
They may have, lordship. The petitioner's son has approached this court regarding the same, and there is an order to that. I think they may have. A coordinate bench has passed this order.
No, this is not the same petitioner.
The petitioner's
case-
son.
Case is that, my lord, son of the petitioner, my lord, prepare, my lord, police in action under group 9, my lord.
Yes.
And where, my lord, learned,
I think they have the
coordinate
same
bench-
prayer in this petition also.
No, there is prayer for, my lord, departmental inquiry of the, my lord, there is a incident was happened that petitioner, the son of the petitioner was going to the office for his job as per the my lord act, but he was beaten. That's why the departmental inquiry was sought for. There is no prayer for compensation, my lord. There is prayer is for also job also only.
Division on division.
Yes, so disposal of his prayer that was made, order was passed there.
But there is manner my that petition, my prayer was not for the compensation. That was
The order has been passed on that.
on that order has been passed, my lord.
Then you have invited the court to pass that order for an appointment
For
in
appointment.
Group 9 police in action.
Here they
You
also
know the consequences of that.
here they also have
You have
paid for
invited
appointment.
the court. You know the effect of this order.
My son is not the owner of the land. I am the owner of the land.
Either
my
you are
lord.
not there. There is a prayer for disposal of the prayer for appointment in a police in action determination.
I am the owner, my lord. I am paying compensation on the
You do
acquired
not want to press now. That's your instruction, sir. Please check up, then file this. Please take direct instructions from the, who is the advocate on record? You are the advocate on record. So you will be responsible, sir. You'll be responsible. While withdrawing, be very careful. When do you want?
Let it be after vacation.
Copy here. Copy here. Copy service
the learned none appears for the petition.
Well, the petitioner has made a very innocuous prayer for mutation. Well, before the respondent number 3, well, the petitioner is the successful bidder and is the auction purchaser under the Surface Act of a plot of land. Subsequent thereto, the petitioner name has been mutated with the municipality, possession certificate has been issued, and also self
State is there. What do you want?
Only very innocuous prayer, petitioner made an application for mutation before the refugee rehabilitation department that has been kept pending. Your lordship can pass the order for consideration. In accordance with law, let them consider.
Not in the absence of the state.
But it's a very innocuous prayer. It has been kept pending. If they find that the application not in order, they can reject. I'm not asking for that in the absence. So I want to steal a mark.
Your prayer has been rejected.
No. That is pending. No reply is there also.
Maybe.
I have been pending for quite a substantial period of time.
What can be done? A request has been made.
Only for consideration, my lord, in accordance with law, my lord. Only this much, my lord. I am not asking for, my lord, any order or they have to consider.
When have you submitted a representation?
My lord, yes, my lord. The representation, my lord, I have submitted on 17th April 2026, my lord.
So,
My lord,
and
because,
today
my lord,
is,
my lord, that,
when have you filed the writ petition?
my lord, the writ petition has been filed, my lord.
28th. Representation is 22nd.
My lord,
What's the purpose of submitting a representation within 6 days? You are filing a writ petition.
no, my lord, that represent.
Liable to be dismissed. Because what's the object of filing this representation demand of justice?
Well, that demand of justice because let me.
What is the object behind? Why
object,
in the appellate side rules also there is a provision
there is
that
a
you have to
provision.
serve a demand of justice?
What has
then.
happened, my lord?
I'm asking you, what's the purpose for that?
Well, previously, my lord, when this, my lord, the mutation.
Kali, you are not answering my question.
Lord.
I'm asking you, why in the rules of the appellate side, writ rules, it has been said a demand of justice is served. Why? What is the purpose? I'm asking you that.
Reasonable time has to be given, my lord.
For
that's
what?
the normal.
For what?
So that they can consider, my lord, and also dispose it of.
And so that the state or the authorities
Will
need
not
not be
suffer any
unnecessarily dragged to the High
Back to
Court.
the court.
So, object akin to section 80 of the Civil Procedure Code. So, you are serving a representation on 22nd, you are filing a writ petition on 28th.
No, there is a checkered history, my lord. That's why,
Maybe
my lord,
since, the petitioner has to come to the High Court within 6
no,
days
my
of
lord,
filing the
what has
representation.
happened, my lord, when my lord, in the, my lord, there is a internet, my lord, when I have downloaded
has
the copy.
prayed for a direction. You have to serve, sir. There will be a change of panel. Please appreciate this.
Yes, my lord, there will be, my lord. I have to cross the face, effect to face this one.
Yes.
My lordship, I am for the petitioner.
Yes.
I'm submitting the affidavit of service.
State is there.
No, my lord. No, my lordship.
State is not a party.
No, NHAI. Union of India.
Union of India. Who is
Yes.
appearing for the Union of India?
Union of India, including
So
the
state is also a
state, is
party.
also party, Your Lordship.
State is also a party,
Lordship.
madam.
And I think the state has a major role in this.
But my lordship.
Without their instructions, it's difficult to do it, Your Lordship.
But my lordship,
Such
previously.
a land acquisition, Your Lordship, act is involved, where the land has to be acquired for the this highway.
But my lordship, you have already passed to order on this same connecting matter, my
The
lordship.
lawyer appear and
Can be done. State is not here.
Okay, my lord. Yes.
Every service.
Port trust. Port trust, so they should be appearing. Lord, I have a supplementary affidavit, my lord. This is a matter I mentioned yesterday, my lord, with respect to the
The
tender.
other side.
That's what I'm. But the one
Not
thing.
served.
Yes, yes. Have.
Who is appearing? Mr. Ashok Jana. Usually appears for the port trust.
Then my lord, somebody else appears, but Ashok Jaina usually appears.
Usually appears.
কবে করেছে ডেটটা? আজকে আছে তো, আজকেই তো অপশন হবে, তাহলে এটা একটু কি হবে, কিন্তু মামলা করতে হবে আমার। সমুদাকে একটা খবর দে, আমি আনন্দ করছি। The auction.
Virtual mode, you are saying that it's very urgent.
Yeah.
So, virtual,
So even physically, Miller, I'm saying
physically,
it's even more urgent.
urgency has vanished.
No, Miller, it's even more urgent now. I'm sure Mr. Mitra is thinking what he's going to, how he's going to, Miller, react to this.
I didn't hear.
Miller,
Restore possession.
yes. Not, Miller, I have a very
By way of
simple
an
prayer.
interim order.
No, I have a very simple prayer. Forgets about restoration of possession. Milord, land was given by Port Trust to Milord.
What is the interim prayer you want, Mr. Chatterjee?
Milord, the tender is to be opened today with respect to the land as well as the structure, and the money has been directed to be paid to Milord, my tenant.
Sitting occupant.
My tenant is, and the money has been directed to be paid to these.
Your tenant is.
Yes, Milord. Land was given to me. Then, Milord, Port Trust approved of that. It was initially given to somebody else. Port Trust approved of the transfer, and it was given to me for the rest of the, Milord, the lease period. Then Port Trust filed a suit for eviction of the land. Structure, Milord, was not Port Trust's. Structure was ours. The structure, Milord, was transferred to, Milord, another company, and another company.
You have transferred that.
Yes. There's no problem on that. Now, in the tender, the Port Trust has said that land money will go to Port Trust and the structure money will go to my tenant. I am on that.
You are not assailing the
Tender process, I don't have a problem. If they say give the money to me, I don't have a problem at all.
but where is your tenant?
Yes, my tenant is that he's also not coming. He's a party here. Kindly have a look at below. Yes, yes. Sorry, Doctor. Kindly have a look at below the.
Is also necessary.
Absolutely. Kindly have a look at 94.
Mr. Chatterjee, can you ascertain who will be appearing for the port?
I can do that.
Please bring some of them.
Kindly have a look at 94 once. And seize below 8.
94.
It's column number 8. Seize below value of the structures to be paid by the successful bidder to Varsi Corporation.
He's, according to you, your tenant.
My tenant, admittedly, my lord, I'll show your lordship the document. Now, what he is trying to say is that by way of a my lord, acceptance letter, he has been accepted as a tenant, my lord, under port trust. Can't be. My subtenant cannot become a direct tenant, my lord, under the port trust if the policy doesn't, my lord, allow them to have that. And that's the judgment of your lordship's honorable court.
Can you ask Mr. Jana?
I'll, my lord, definitely. Passes it over, my lord, if I can get him.
Jana appears.
Probal Mukherjee also appeared at
Also
one point of time.
Mr.
Mr.
Mitro-
Mitro appears for port trust as well.
Mr. Mitro cannot appear in
Senior
that
advocate.
case unless he is.
Even that is the case with Mr. Mukherjee as well.
Yes,
হ্যাঁ,
but,
port trust আমার বিরুদ্ধেই দাঁড়িয়েছে
you can
port trust.
you can inquire from Mr. Jena.
I'll do that.
So Kollol Bose also.
So they have
They appear-
varied my lord, legal.
Inquire from.
But I don't know who the advocate on record is. If Mr. Jaina, my lord, is the advocate on record, then
So Mojumdar, are you appearing in this matter?
with me.
But assisting Mr. Chatterjee.
Yes, definitely. No doubt about that. ই আসেনি port trust.
এটাই এই করতে হবে এটা তো এই করতে হবে।
সেটাই বলছে যে
But
একবার
kindly gives us a short stay, not it's my property.
I will do that. Please inquire. Please ask Mr. Jena to come.
Normally he doesn't appear nowadays. Normally.
Doesn't appear.
Normally.
তো তোমাদেরই তো ঘর
No.
অশোক জেনা
কি গো বুঝছো না আর Aquilo.
এস জানান না কিলো
I'll find out from Aquilo or S. Jalan. Mr. Mitro says they appear. I'll find that
one
out
of the
right.
matters, Mr. is somebody on behalf of
Snehashish.
Snehashish appeared.
Snehashish appeared.
S Jalan appeared.
Give that a time.
Why not?
অত দেরি করবার দরকার নেই 12টা 12 o'clock
এর মধ্যে পড়ে আসতে পারবে
কেন কি আর পড়বে ইনস্ট্রাকশনে আসবে
আচ্ছা বলছেন 12:30 কোন না 12:30 কি অসুবিধা
If he can appear, please give a copy to him. That is why he has to go.
Please,
through
sir,
that.
we'll do that.
He wants, he has to take instructions, come at 12:30.
Mr. Konar can not
Please sort it out. If you can give him a copy, because he has to also take instructions. 12:30 রেখে দাও।
আরে ঠিক আছে 12:30 ঠিক আছে
Yes.
আচ্ছা supplementary order.
Yes.
Can I see my last
That
order?
matter.
Can I see my last?
Mitro, sorry for giving you trouble because this was at 3 p.m. as per the last order. But it was by mistake because from 2 p.m. I have a division.
Very well. That's
That's
not
why I have posted.
that's
it.
no difficulty, my lord.
So
As a last chance, document given because here there is no question of consent.
now, Mr. Mitro, there is a difficulty because
No, there is no question of consent. There,
not a question of consenting, but the question of because it has to be now a positive order against them or a direction, some
Yeah, but
directions
this
upon
is
them.
as per the notification, as per their
But
fees.
the request was made. You are appearing, madam.
No, she is with
No,
us.
she saw the print.
A request was made on behalf of the state not to.
I know, I
take
have
up.
heard about.
So might be something again. They will be saying that we were not there because
Lord, you kindly fixes 1 day for vacation. We have
I think it has to be
last week of vacation if possible.
one thing. I can keep it 1 day under to be mentioned just before the vacation because you have to give copies to them also. If please give copy to them because the new panel he has to take some instructions because the earlier advocates they knew about this matter. So they have to be given some time so that they in the meantime they can take time. I can keep it just after the vacation.
তুমি এসে করে দেবে
নেই আমি 13 তারিখে চলে যাচ্ছি
ঠিক আছে সম্পত্তি সব very well Lord, you kindly keep it as a
otherwise keep it on the review.
or Lord, you keep it on the reopening. We shall serve once the panel is made. We shall
If I keep it on 18th,
May, ঠিক
18th May.
18th or 19th.
And I have to be a difficulty, but then it will be the
So
same
only,
position.
only I am telling you, I will keep it under the heading to be mentioned with an understanding that if prior to that you serve a copy in the office of the government pleader, so someone must be engaged indicating that it should be taken up on 18th. So the advocate who comes, he will be apprised of that, and thereafter
Make an order. I'll make an order to that effect.
and after that he can take instructions. I will be posting after the vacations for hearing. Only for that limited purpose, I am देखिए file टा दिए. Mr. Mitchell, honestly. Please do the server copy of the orders, please annex, and even if they have submitted, please indicate that specifically in the letter
Yes.
what was
What was
submitted by.
submitted by?
Otherwise, it may be they may be under confusion. Please say that these were the documents. You know it better how to. Please advise your. Yes, next. Okay. Not today. Yes, not. Yes. Take it back. Take it back. Yes.
But I am for the petition. My lord, may I request one thing? Your lordship permit. My lord, fix this matter up post 1 week after vacation any day under the same heading. In the meantime, I will serve again to the GP. Not service is complete, then everything will be complete. I hope so.
Item number.
Item number 10.
Item number 10.
Any day
The
after
senior
1
advocate appearing for the. Yes, next.
I'm for the petitioner, my lord. The service has already been completed. May I permit to file affidavit of service? Matter regarding, my lord, removal of encroachment and under construction from the road margin land
What
in
can be
front of the
done?
petitioner.
You have to serve again upon the government leader.
My lord, 22nd April, notice was served to the GP. 22nd April.
Now the panel will be changed, sir. That will not
Then, my lord, can you
suffice.
take it after 17th or 18th of this month?
List this matter.
Item number 12.
Taken.
Item number 13.
Served, my lord.
What can be done? Yes. Month list of June করে দিন. Month list of June. Yes. Another
My
second.
lord, let it be, date been fixed. Date, let it be, date has been fixed, my lord.
Let it appear in the month list. I will consider this. Yes. Next.
Item number 14.
I am for the petitioner, my lord. Petitioner, my lord. I
Yes.
serve, my lord, all the respondents. Only by consider my representation, my lord. I serve all the respondents.
Cannot be done in the absence
Only,
of the state.
huh?
Cannot be done in the absence of the state. Yes.
In my next
Not
date,
today. Yes. Next.
next date, 18.
Not today. Yes. Next.
Number 15. Item number 16. Item number 17.
Not today. Next.
Item number 18.
My lord, 18, I'm appearing for the petitioner.
Yes.
Item number 19.
My lord, one indulgence, my lord, kindly, my lord. My lord, may there be a direction, my lord, to serve a pen for fresh upon the government pleader, my lord, because, my lord, I am also aware, my lord, the panel will change, my lord.
Serve. Yes.
My lord.
Item number 19, I am awaiting.
Yes. Not today. Next.
Item number 20. Not I have for the petition. Date is the next.
Yes.
21. 50. 23, 24. 25.
In 25 with the petitioner, in this matter, Learned Advocate Joydeep Ghosh appearing for the petitioner. My lord, in this one, state is not concerned party. Only party is the IFCI, Industrial Financial Corporation India, and the concerned party is West Bengal Industrial Development Corporation. My lord, on the last occasion, you, my lord, directed to file the reply against the opposition filed by the WBIIDC. My lord, he's on the way, my lord. My lord, may I file, my lord?
File the reply.
Reply. My lord, he's on the way. My lord, can it be pass away?
Pass
Stay.
forward. Next.
26. 27.
Not today. Yes.
28.
Similar is coming, sir.
Not today. Next.
29. 30. 31. 32. 33.
33 private respondent.
34, 35, 36, 37, 38, 39, 40, 41, 42, 43, 44, 45, 46, 47, 48, 49, 50, 51, 53, 54, 5, 6, 7, 8, 9, 60, 61, 5, 57, 58, 59, 70, 75, 38, 39, 80, 81, 84, 85, 86, 87, 88, 89, 90, 91, 92, 93, 94, 95, 96, 97, 98, 99, 100, 101, 102, 103, 104, 105, 106, 107, 108, 109, 110, 111, 112, 130, 140, 150, 160, 190, 120, 121, 123, 124, 125, 126, 7, 128, 129, 130, 131, 132, 133, 134, 135, 136, 137, 138, 139, 140, 141, 142, 143, 144, 145, 146, 147, 148, 149, 150, 151, 152, 154, 155, 156, 157, 158, 159, 160, 165, 169, 170, 171, 173, 174, 175, 176, 178, 179, 180, 181, 182, 183, 185, 186, 187, 188, 189, 190, 191, 192.
Lordship 192, I beg to appear for the petitioner. Lordship, on the last occasion, the service upon the private respondent was not complete. It has been effected. But Lordship, the matter is, since your Lordship is
Not to serve the
on
GP.
a fresh service has to be affected. Lordship may kindly
I'm
fix
making not today, yes.
No, Lordship, the matter is since February it is appearing in the list in the motion. So if your Lordship may kindly fix as a matter on
Serve.
yes, I will affect service, Lordship. In the
Making
meantime,
it only not today, yes.
193, 194, 195, 196.
Lordship 196, I beg to appear for the petitioner. On the earlier occasion, the service was not affected on the private respondent. It has been affected, Lordship.
Today, yes.
197, 198, 199, 200, 201, 202, 203, 204, 205, 206, 207, 208, 209, 210, 211, 212, 230, with 240, 250, 216, 217, 218, 219, 220, 221, 222.
Password. Yes. Yes, Mr. Kaur.
I don't think the other side is there. So, but, no point doing the matter if they are not there.
What is the issue?
But the issue is cancellation of a plot of land. This
KMDA.
no, Lord, this is WBIIDC, and Lord, this is Lord in Kharagpur. The leasehold right was mortgaged to a bank, and by surfacing Lord sale, a sale under surfacing, I have purchased, and then Lord, the issue was assignment. Now IIDC said that we will not assign. You have taken it from IFC.
Oh,
IFC.
yes, yes, that matter.
That matter. Lord, we spent a lot of time in deciding as to who will execute, and in the process, Lord, I could not, Lord, start my business because I won't get a license, Lord, unless the lease is assigned. So now, Lord, IFCI has agreed to execute.
Now WBIIDC has to come up.
And they are, Lord, last time the matter was fixed by a lordship as under to be heading to be mentioned, but somehow they have not, they are not cooperating. So I think the matter will have to be heard.
Has to be heard. Then what can be done? You have to serve. That panel may also change. I do not know what will.
Who
Who is the learned advocate who is representing?
Kindly give me 1 minute. Oh, Mr. Nag is there.
Well, I'm appearing for WBIDC monitors.
Yes.
Are you ready to do the matter, Mr. Nag?
Yes, I'm ready, my lord.
Where is IFCI is not
Oh,
here.
the IFCI is also.
So if you want, I can keep it on Monday higher up.
Yes, Lord.
If all of you agree,
please.
I will. Notice of
yes.
IFCI.
Notice of
What is the item number?
It's 25, not in today's list.
25 টা order record করে নিন। Mr.
Respondent and IFCI is blood because I have purchased the property from IFCI. the assignment, Lord, has to be done by IFCI. So I'll serve IFCI. We'll serve, Lord, formal notice to everybody. Lord, kindly keep it on Monday, because if IFCI appears,
You
then
have to serve upon the state, then keeping Monday will be of no use.
Lord,
Because practically it will be
maybe serve upon the learned advocate, Lord, who appeared, Lord, on the last occasion.
who appeared. He might not receive.
Oh, I see. Then, Lord,
And
Wednesday.
after Saturday,
Yes.
it will be a difficult.
I think things will improve. Kindly keep it on Wednesday or Thursday, Lord. Maybe next Friday, if that is that commences to alert.
What is I'm thinking that after the next week, once it regularizes, motions will come. It is
So,
after
Lord,
all,
kindly, Lord, keep it
let
on
it appear on Tuesday.
Yes.
Let it appear in
let
the
us try.
meantime if something can
Yes.
be done.
Because state has nothing to do, directly or indirectly, state has nothing to do. I don't know why state was made a party. State has nothing to do. It is WBIIDC and
Right, I
IFCI.
do one thing. I keep it under the heading to be mentioned. Serve a notice. If all parties are there, the things, other matters are cannot be taken up, I will proceed. এটা to be mentioned রেখে দিন Tuesday. The learned
Let it appear in a regular list, Lord, as it is appearing
to
today.
be mentioned, I think it will be better.
Because
If they say
if Mr. Nag, Lord, can appear and IFCI, Lord, appears, then
if other matters can be taken up under the to be mentioned also, I can hear that.
much of it.
That's what পাঠিয়ে দিন। I mean, not today. Yeah, there's a division bench. There's a division bench. What can be done? Just hold on. Who is appealing for the other side, please?
I have already informed him. He said that yes, he will be coming if you are.
Please bring him. Yes.
I appear from the respondent just now received the brief.
Just now received.
But we mind if he wishes to
Yes,
come
the
back with the
private respondent, Mr. Majumdar.
yes, he has been served. Now, my lord, without following the provisions of the 1971 Act, my lord, I have been sought to be evicted after creation of a new tenancy, number one. And number two, my property, which is building and assets, is put on auction. The sale proceeds whereof will go to the subtenant.
What is that? Yes, show me your lease deed.
My lord, I am taking the point of maintainability. My lord, nowadays, my lord, the scope of writ petitions are being enlarged to a big effect, my lord.
Now, please.
Admittedly, he is not in possession. He is not in possession. Now he is challenging a tender giving to, my lord, the tenant. Who is the tenant under me? So, my lord, it is the remedy lies under section 6 of the Specific Relief Act, not under writ petition. My lord, he has to first have the possession. Well, he is not in possession. That is admitted in the writ petition.
Please come to two documents.
Well, how can a writ is maintainable when, my lord, he is not in possession and his remedy lies under section 6 of the Specific Relief Act?
Please come to page 69. Though you badly lost the title suit number so and so filed by this port against you, which is pending for execution for a long time, you have not paid any amount towards port trust area.
Suit.
Yes.
That's a civil suit. They filed.
Eviction against you.
Yes, yes.
For
Eviction.
of the land. Where is the plaint?
That's not there. That's not there. I have got annexed the decree. You have not paid any amount towards port trust area dues. Moreover, it is found that you have inducted one Varsi commercial into the premises without any authority whatsoever. In the meantime, total occupational charges in respect of the aforesaid occupation has risen to so and so. But he is raising this demand on me up to January 2002, which is exclusive of interest to be paid on the said dues as port rules. It flows from the above. You are not only depriving Port Trust, a government body, of its legitimate dues, you at the same time are indulging the devious and illegal means to mint money from the occupation. You are hereby advised to remedy the breaches by payment of port dues and removal of unauthorized parting with possession within 21 days from the date of this letter, failing which appropriate actions as will be deemed fit and proper by this office will be taken without further reference being made to you from this end. Not the 1971 Act thereafter at the most, but no recourse made to those provisions. For the time being, I am not disturbing your lordship on that. Please come to the impugned notice of e-auction, which appears at page.
No, where is the decree passed by the civil court?
Yes, no, that is there. A decree for
Execution
eviction, not for restoration of possession.
Execution also.
That's right. No, the ex parte decree is at page 45.
That ex parte or no ex parte?
Very
I
well.
cannot go into that.
45.
Page 45.
Yes. But this communication is after that.
Schedule 46.
So this is the decree which was put into execution. It has been executed.
Yes.
It is. Let us for the time being assume it is executed. There is a dispute which your lordship will finally consider. Now, please come to the impugned notice of e-auction. Not he has at the most a lien on the land or the rent, not on my property.
Lease deed to you.
No, I was an assignee of a tenant. Now, please come to that assignment.
The original lease deed.
No, that's not that they can produce.
Why?
No, I was an assignment. The assignment document is there.
Assignment, when it is assigned, you will not be having the original deed, Mr. Majumdar.
But page 33. No, I don't have this. Not page 33.
You ought to have taken that.
There's a photocopy there. There.
It's
Page
photocopy
33.
will
Yes,
do.
yes.
Where is that?
Page 33.
33.
Yes, yes. No, there is a consideration.
33 is by your assigner.
Yes.
I want to see the original lease deed by the Kolkata Port Trust.
No, that was to the assigner.
Yes, when,
But that
when
I
it has
don't-
been
I
assigned,
don't
Mr. Mojumdar,
I don't
the
have that
original
copy.
deed has to be
It's
given
not
to the
disclosed.
creditors.
It's not disclosed.
Yes.
No, there is no dispute with that. No, they have accepted this. Please come to page 42.
Yes.
Lease of land measuring so and so square feet for a period of 10 years. Issued to me directly.
Yes.
Necessary sanction of the assignment of the unexpired portion of the above lease has since been obtained in your favor. The assignment of tenancy of the unexpired portion of the lease is being given effect to in your favor with effect from 1st August 1969, from which date rent has been charged in your name. No, there is no dispute with that. Now, now please straightway come to that e-auction notice.
Yes.
Not all payment made, not in terms of not the rent. Not please straightway come to page 3 documents, not from the notice, at pages 94 and 135.
94.
Not proper, the assets, not the building and other assets are owned by me. I had paid a consideration to my assigner for the purpose of that. It is only the land which was being rented to me.
Yes. So land. So according to you, your claim is only with regard to the structure.
Structure. Now please come to 94 once.
Yes.
But the third last column.
Yes. Second last column.
Second and third. Not I come from
Second and third.
Yes. Please see valuation of structure as per valuation report in rupees, taxes extra. Nothing is mentioned. The next column, value of structures to be paid by the successful bidder to. What see? Now please see the title of that property in respect of the writ petitioner. 35 and 37. There you go. 34, 35 and 37. The second paragraph. The vendor has agreed with the purchasers to assign his tenancy right for the unexpired portion of the said lease and to sell all buildings and structures belonging to the vendor. On the page 34.
34. Yes, the vendor.
The vendor has agreed with the purchasers to assign his tenancy right for the unexpired portion of the said lease and to sell all buildings and structures belonging to the vendor on the demised land as mentioned in the Schedule B annexed here to in favor of the purchasers at and for the consideration of rupees 73,000 only in 1969. The vendor has obtained permission in writing from the commissioners for the port of Calcutta, for the assignment of the said tenancy right and to sell the said structure on the devised land.
Where is that permission? Please show me.
No, that's there. No, that assignment was already.
Permission to sell the structures. Please show me.
Structure is of the.
You have said paragraph.
Structure is of the assigner.
Paragraph 3 states that obtained permission in writing from the commissioners for the assignment.
For assignment of the said tenancy right and to sell the said structure
Where
of
is
the.
that permission?
Yes, please come to 42 once again.
Yes. Paragraph. The assignment of tenancy of the unexpired portion of the lease is being.
The assignment of tenancy of the unexpired.
Regard to the land.
Yes, it is also noted that you undertake the liability for payment of the sum of rupees so and so, being the area tax on the structure standing on the above land for the period from so and so to so and so. It is 1966. In base, the same becoming payable. In case, the same becoming payable.
56 to 66 সেটা টাইপ আছে পরের পাতা
But in any event, the sale.
It's the area tax on the structure. Here,
Tax on land.
Transfer, sale, that has not been
But
given.
page 94.
What is that in the recitals? That's not the.
Page 94, the sale proceeds would not go to the tenant otherwise. If it is port's property, but the logical conclusion is sale proceeds would not go to Warsi Commercial. The auction value would not be passed on to Warsi Commercial then.
ও নিজেই আলাদা করছে the land and the structure.
Lord,
Landed ওর কাছে
what was leased out was the land.
Where did you construct, Mr. Bijli? On the land.
On the land. And I purchased it from.
After the possession has been taken of by
No, 1969.
No. After the possession has been taken by execution, what remains?
Where is the possession taken?
Possession of land. Please see the decree now.
Degree that it's on land.
On land.
Structure there is nothing.
Please come here to the eviction decree
Yes.
at page.
I to segregate করেছে।
No, probably as on today, we don't need to go beyond the e-auction notice. Is there on? No, I have also got the 2021 Act.
Your building will be on air, Mr. Chatterjee.
But they have segregated.
Land. Please come to.
On the air.
No. It was a go down.
Mr. Mojumdar is on the air. Land, you have been dispossessed. Your building is on air.
With the land. No, they can't have a lien on my property. On the asset otherwise.
Yes, Mr. Nag, what do you say?
Now please come to pages.
With regard to the structure, what do you say?
My lord, I tell your lordship two things, my lord. First, my lord, what is his right? Because there is an execution, and after execution, the occupier.
So you are not claiming anything with regard to the structure.
My lord, yes. Under section 6.
No.
Under my lord,
Structure you have said it would be paid to Watsi, not to you. This C94.
my lord, the Watsi was given with the structure itself. Watsi was given the tenancy with the structure itself. Now, my lord, before my lord, I go into that dispute. Before I go into that dispute,
Please kindly come to page 94 once. Lord, you have said the
91 first.
90.
It's allotment of land.
No, I'm coming to that. 94, there are two aspects. One is area to be leased out has been seen. Annual reserve rent, that is something has been said.
Lordship.
Now, value of the structures according to you, 8th column
8th column.
of that tabular chart, 94.
Lordship.
94.
Lordship.
It has to be paid to Watsi. So you do not claim that amount.
No, it's not that simple. I tell you, lordship. My lord, why? My lord, why? My lord, lordship, kindly come to Roman 2 in the note. My lord,
Roman 2 in the note, yes.
Yes, now, my lord, this is not a normal tender. My lord, lordship sees, lordship has also come across this type of matters. All prospective bidders, except FRR bidders, are requested to note that they shall have to deposit EMD against structure. If any, as mentioned in table, my lord, now, my lord, pausing here for a moment. Now, my lord, Watsi trader is now the occupier of the land with structure. Now, yes, land and structure. My lord, it's in the, they have.
Sir, you have executed a lease in favor of
Yes,
Watsi.
yes.
Where is that?
My lord, kindly come to page.
Let things be unfolded. Lord, how this looting is going on.
My lord, no looting. Kindly come to page 70. It's their document.
Watsi has inducted two subtenants.
My lord, there was a subtenant. If they have been there is a title suit eviction against
I am
them.
not on
What
that.
right
I am
they
on
have?
that.
My lord, I will clarify that issue. My lord, kindly come to page 70 first, my lord. The matter has allotment of land. My lord, kindly sees the letter. Whom it is written? To Messrs. Watsi Corporation. Allotment of land measuring amount such and such, comprising of such and such, built hydro such and such. This matter has been considered by the appropriate authority. This is to inform you that it has been to allot you the aforesaid land earlier granted to in favor of Messrs. Modern Packaging Industry of monthly lease basis as is varies condition at the rate of such and such per square feet plus usual occupier municipal tax such and such. Now, my lord, on the basis of this has been granted as is varies basis. My lord, I tell your lordship what has happened.
On structure.
On structure, my lord. On structure. On structure. Municipal tax on structure. So it's as in various basis it has been given. Now, my lord, it was given, my lord, in 2002. My lord, for last 24 years, that was not challenged. They have suffered a decree that was not challenged. Now, my lord, after 24 years, they are before your lordship saying, my lord, their right has been extinguished. There is not a single penny they have kind of right over the land in question. They have nothing. Now, my lord, after 24 years,
when I put the property on tender, now they want to put a spanner to this. Well, has the execution decree been challenged ever? Has the disposition been challenged ever? No, they have waived their right. They were sitting on the fence. And when the matter was put on tender, now they want to put the spanner. I'm sorry, Malad. I'm sorry. I'm sorry, Malad. Now, Malad, the confusion that has been.
It reminds
Now-
of a very old Bengali proverb: "Who shouts more?"
Yes. Now, Malad. I think tomorrow there is no speeches.
Only announced.
Now, Malad, the Roman 2 I was showing. Malad, fast
Roman 2
of page 94, Malad, I was showing to you.
Yes.
Now, Malad, this is Malad.
Auction of what? Now you are trying to auction what?
Malad, the entire thing, land and structure.
Land and structure.
Now, Malad, kindly, there is, Malad, they are trying to.
So what happened to Varsi now?
Now I tell you, Lordship. Malad, this is the tender of fast right of refusal. So, Malad, it's a tender.
Sitting occupant.
Sitting occupant. So, if it is sitting occupant, these 9 Lordship has pointed out will not be applicable because they are with the structure now. Now, if they refuse the tender, or failed in the tender, this what say, if somebody else come, then they will have to pay the amount to the Varsi status. So this is the, Malad, Lordship has come across to this, Malad, many occasions. So this is the thing.
But this is creating only problem. Value of the structure to be paid by the successful
Malad,
bidder to Varsi. That is their challenge that
Malad, it is Malad now, Malad, it is now, Malad, it is now well-settled proposition of law. Mandamus can be given if somebody has some kind of right. Malad, I am going into the basic of the disputation. Malad, they are suffering eviction decree. They are saying they are not in possession. They have disclosed a document which says, Malad, 2002, Varsi brothers, everything has been given. So, Malad, today, what right they have? Malad, if they at all have any right, Malad, Malad, whether they have made a prima facie case in respect of their right over the property so that they can even come to court and ask for order. Malad, I will tell you, Lordship, Malad, they don't have any right. Now, Malad, Malad, if Lordship, they have some kind of objection in respect of the property, Malad, kindly see this.
Yes.
Malad, copy as an act. Malad, kindly have a look at section 6. Malad, I always have. Malad, in terms of APL judgment, any property left in a property, after execution, I always have the right over the property. Lordship says, section 6, where the person has been evicted from any premises under section 5. Malad, I suppose, Malad, here section 5 situation was not there. There was an eviction suit. The estate officer must giving 14 days notice to the person from whom possession of the property has been taken after publishing the notice. At
it
least
has been evicted by
eviction decree.
By a eviction decree.
By a eviction.
So I think these provisions of
Don't
this
apply.
act may not apply.
Can't apply.
Malad,
Provisions of this act may not apply.
They have themselves chosen not to.
I tell you a lot.
This it is maintainable before Group 1.
No, because not without following this.
It's a
They are now trying to auction.
Mr. Mujumdar, you are bound by the decree. Possession has been taken. How
The
can
possession has not been taken.
not involve this
But
71
Varsi
Act?
is
Well, look
a
at the prayers.
subtenant by me, through me, who has been now sought to be inducted by court.
That's
Now,
a,
all that they can do is
Mujumdar,
please have a
that's a dispute between you and your subtenant.
no,
Yes.
no, not
Take
at
your
all.
rights
Yes.
against your
Please
subtenant.
have a look at the provisions of section 28 of the new act now.
New act.
Yes.
Without invoking this, you can't do that.
But I say that you cannot dispossess me without provisions of that act.
You have to invoke this act.
Please come to section 28. That's the only.
Not go
What
into
is he
that
saying?
because
He has been
there's a civil court
evicted in
decree which has
2002.
been
Right.
executed.
That is on the land.
What land?
Only on land.
Only on the land, not on the property. Not what happens to the registered conveyance then.
And how does he come in? Comes in by a license.
But I have shown to your lordship's page 34, 35 and 37.
According to you, the structure is not owned by the.
Yes.
That's your submission. So structure is not owned by them. So according to you, you are the owner of the structure. Varsi is your tenant. So it's a dispute between you and your
They
tenant.
have issued
Please
this.
sort it out
But
as to whether he will be entitled to that amount or he will be
I am not to the amount or not.
Trust is in no
But
way
I am
related.
today challenging not the notice inviting tender or not the e-auction notice, but which seeks to not confer the property rights to Varsi in respect of a structure.
But that does not relate anything with regard to this act, because you have suffered a decree, because lease, you are the assignee of a leasehold right.
Right.
So initially, that is why I wanted to see
with a
the
subsequent
original lease deed.
with a
Original lease deed was only with regard to the land, maybe with a right to make construction.
not subsequently with a tenancy recreated. Please come to that document which I had placed. Please come to that document once again.
Yes.
Page 69.
Yes.
I will be also relying on 69.
This is much after eviction decree.
Yes.
Though you badly lost the title suit number so and so filed by this port against you, which is pending for execution for a long time, you have not paid any amount towards port trust area dues. Moreover, it is found that you have inducted one Varsi commercial into the premises without any authority whatsoever. So, who is in possession? The petitioner. In the meantime, total occupational charges in respect of the aforesaid occupation has risen to 20,33,000 rupees up to January 2002, which is exclusive of interest to be paid on the dues as per the port rules. It flows from the above.
Have you challenged this page 70?
Page 70.
Yes.
No, he's a subtenant under me.
This is allotment of the land made in their favor.
Somebody has been allotted. Now,
today challenge, if wrongly it has been allotted, you have to challenge that.
Yes.
No. He's a subtenant under me. He was paying rent to me. But I am not on this question as to who will be the. But all that can port do under the provisions of section 28 is to have lien on the rates, nothing more. He can't have a lien on the property which is owned by the petitioner for the purpose of e-auctioning to recover rights, not for the subtenant.
There's a dispute whether that structure remains, because as per this document at page 70, please see page 71.
71 দেখতে বলছি, 71.
Yes, please come to 71.
Yes. Only temporary structures will be allowed to be constructed. So after that I do not know. That's a disputed question of
This is for subsequent permission. This is for subsequent permission.
This is for subsequent permission to raise construction.
Right.
Yes, according to you, you have laid out to Varsi. You have laid out to Varsi in the year 1999.
Before that.
In the year 1999.
97, 99, very well.
99. So after that, this allotment was made in favor of Varsi.
Right.
With power to make temporary structures.
Yes. Right.
Well, a disputed question of fact.
So whether your structure is there, not demolished, I cannot go into that.
Admitted to. What admitted?
Not admitted.
The reply to RTA.
They have not admitted. They are not bound by
They are. Please come to 77 ones.
What 77?
77 years.
That's an RTA reply by them, admittedly.
RTI reply of 2010, Malad, can you mark that date?
Of course.
The structure is there in 2010.
কোথায় লিখেছে?
Yes, ownership of the structures not readily available in the office.
In the office of the RTA.
Yes.
Yes.
Why they will go into that?
But please come to that.
If you say, Mr. Chatterjee, you say you are the owner. Varsi says they are the owner.
Yes.
You fight it out among
Varsi doesn't say they are the owner.
But
That's
Varsi,
the problem.
please come to 34 ones. 34, 35 and 37. But the eviction decree is only in respect of the land and not the structure. Please come to 34. Please see 34, 35 and 37 in that order.
And they have segregated it, land and structure.
We have not segregated, Malad. I have clarified the point.
That's 94. They have segregated it.
Yes, 34.
Yes.
But I have shown to Lordship 34. Please come to 35.
35.
Yes.
In further pursuance of the said lease and paragraph 2, in further pursuance of the said lease and for the consideration aforesaid, the vendor as owner of the structures and buildings standing on the demised land.
How these recitals bind the port trust?
Now please
They give sanction.
Please show me that sanction to sell the structures. That's not there.
About giving the license, they have.
No, they have only given permission to assignment of tenancy,
Yes.
nothing more than that.
There are
Structures,
municipal
they are
But there is a valuer's report. There is a valuer's report.
The valuer's report.
There is a valuer's report which is under challenge also.
See paragraph.
Please come to page 37.
Yes. Page 37, valuer's report. Where is
No,
that?
no, it's the schedule.
Yes.
The said piece or parcel of land comprising of so and so square meters.
Mr. Mojumdar, that's between your assigner and yourself.
Right.
That does not bind the port trust.
But it says commissioner has given permission. Please come to that page once again. Page 42. Oh, the commissioner has given permission. Lease of land.
No, commissioner has given what permission? That is what I want to
Lease
know.
of land measuring so and so
Yes,
square
only
meters
land.
And then
for a period of 10 years. Then please come to.
She says tax on the structure.
exactly.
So on tax on the, there's a structure, there's a tax on the structure.
So-
Ownership not disputed.
So 1969
then-
Varsi has not constructed.
And no record. So you may be the owner.
So
Varsi may have,
1969.
Varsi may have demolished that. They have
Yes.
constructed.
This guy has come and said that.
So let them come.
Well, 50 years in between.
Yeah, if they have got that, if you have any claim against Varsi, you can recover that.
But if there is a building which has been constructed and not I own the building for the purpose of this.
Proves that
There is a
in a proceeding that
there is,
cannot be
but there is a
proved in a-
valuation report. Not, let
that
us
cannot be proved in a writ petition.
not can it can the- not I have shown to your lordship section for 28. Please see not what the lien can be written on. Accord 33 to the accord.
Well, even the tender is of February 2026.
Yes.
And we are in May. Malad in the tender, he sent urgent. Malad copy has not been given. And Malad today is moved.
Then
On the
Yes, yes,
question of fact.
But liaison is only on the rates.
Where is the notice, date of notice inviting tender?
Malad 23rd February. Lordship right has
23rd February, which has been extended now.
Structures.
We are doing the tender now, today.
They are doing it today.
Moment you have mentioned yesterday, today.
That's
it is
all
being
the
taken.
documentation.
That's the supplementary affidavit. Please see the notice.
Let the.
Well, I don't have any copy of the supplementary notice.
But your document, you ought to have dim knowledge.
Oh, yesterday they will serve, but today I will come with everything.
Please
Mention
show me
the
date of the tender, notice inviting tender.
But please see, this is dated
23rd February.
This is dated opening
Malad, Lordship,
8th
please,
of May
Malad,
2026.
Malad, 144 Lordship
This
take.
is another thing. You are challenging this.
144.
This notice was of 23rd of February.
Yes, this has been extended on 8th May 2026.
Last
Please see
date.
this. Please
That's
see
the
this.
last date.
No, opening.
Please see the opening date.
It's a different thing. You are challenging, Mr. Chatterjee, the terms of this tender notice.
Please come
which
to-
was dated 23rd of February.
Please come to page 91
Available
once.
in the website. It's available in the website.
Please come to
Other
page
than
91
vigilant.
once.
You are not vigilant.
Malad, 2002, from 2002 they were not vigilant. Malad. Their right has been extinguished, my lord.
But today it is not like that. Not one will. Please come to the two documents. Page 91 and then not the eviction decree. But they themselves not get it segregated.
So that's
They are trying to hijack on my property.
What hijack? When the last 50 years, who has created?
So it becomes your property.
Who has created? Who has demolished? Nobody knows, my lord.
Whose property?
Well, look at the prayers of the writ petition.
E-tender
Now,
two-part
do
system.
one thing. This amount, you please return, don't pay to Varsi.
Lordship.
I'm keeping it on my.
Lordship, I am agreeable to that.
The
Direct them to not produce a valuer's report.
that
No, original lease.
Well, I will file affidavit and by which I
The
will.
valuer's report.
It's on Tuesday.
What?
মানে আমি দিল্লিতে থাকবো তোর অসুবিধা আছে
No, no, please.
to be also because
Yes, yes.
it's the amount which is to be paid to
What?
Varsi.
Yes,
They will be entitled to.
yes, yes.
So you hold the auction or tender, whatever it is.
Lordship.
Please do not release any amount in favor of Varsi.
Malad, if Malad, kindly add an if Watsi became successful, I don't the amount has.
give it to him later
No, he doesn't have to pay even.
Yes, that's a
Yes.
different thing altogether.
Yes, that's what I'm saying.
Varsi is the
That's the game
successful-
plan.
What's
That's
the game plan? What is the game plan?
Varsi is
That's the game.
What is the game?
I'm only concerned with the amount.
Hmm.
So please don't release the amount in favor of Varsi.
Lordship, Lordship.
The
Phase e-auction. First is technical qualification, the
This
other
is
is
game
price.
plan.
The other is price bid.
This is
So the other is price bid. Let them not open the price bid.
no, no, no,
The
no.
date of opening the price.
They have not
No, my lord, I'm opposing.
indicated.
My lord, I am opposing to
They
this.
have not indicated.
My lord, they don't have any right. My lord.
Your anxiety was that this amount should not be paid to them.
No, my property should not be put on sale. That's my anxiety.
The After the new motions.
Lord,
Just after the fresh matters.
Lord, grateful, my lord.
But only one humble submission. Not
What?
on the returnable day, let them produce not the original lease deed. That may not be required.
You will be having the copy of
The valuer report. The valuer report. The valuer report for this building.
My lord, this is old records. I cannot assure you. I will try, my lord. I can't assure.
The valuer's report then. The valuer's report which has been referred to in the tender.
His claim is against what?
Where is the other matter? Yes.
222.
Who is appearing against you? Mr. Naik, you are appearing?
Yes.
What is the urgency?
No urgency is there, my lord.
He says something
Election
Let it
is
be on-
on, today it is, I don't know why, by this time I think.
election. Today is the date of
Some
elections. Let the elections be held.
Well, let it be held. I am not saying, but let it be held. But there must be some order, my lord, so that we can say that yes, this is at least, my lord, whatever is the election, my lord, let it be, my lord, have the.
My understanding, there is no urgency at this stage, and
The
other
But this is an application for review, my lord. This is an application for review, my lord. Well, this is an application for review, my lord. I appear for the review petitioner. My lord, at the beginning, may I say, my lord, that since last evening, my lord, I am not feeling well. Possibly my blood pressure has shot up. Possibly, my lord. So we could not have an effective conference yesterday. Still, then, my lord, I am duty bound to assist your lordships to the best of my
What do you
caliber,
want?
my lord.
What do you want? Can you proceed today, or you
My
have
lord,
difficulty?
I will try, my lord. But if I fail, I'll tell you, lordship, I can try. But my lords may kindly allow me to, my lord, proceed at my own pace, my lord. Kindly do that.
All right.
My lord, there's an application, though the registry did not mark any delay, but is it working? Though the registry did not mark any delay in preferring review, but my lord, we have seen that since from the judgment passed by the division bench, my lord, we preferred a special repetition, which was summarily dismissed. So, my lord, and then we came back and filed this review. So, my lord, there was some delay, and we have made an application, my lord,
What is the delay according to you?
delay is 58 days, 52 days, my lord. Paragraph 1, lordship may kindly see, and we have also, my lord, lordships, this is
Check up, this delay has been computed. It's enormous.
Acha. If that is so, my lord, lordship,
839 days.
very well, my lord. Lordship may kindly, my lord, I bow down to that, but that may not, perhaps, my lord, is the right reflection of the affairs, my lord. My lord may kindly turn to page 13 of my page 12.
Memorandum of review.
Now, of my application for delay.
Application for delay.
The lordships are aware of this judgment of the Supreme Court, my lord, that during the period of COVID, their lordships of the Supreme Court, my lord,
Extended the period of limitation.
That's right.
No, is it during COVID?
That's right, my lord. I have explained, my lord, in detail. প্যারাগ্রাফটা বলুন কোন প্যারাগ্রাফে এক্সপ্লেনেশনটা দিয়েছেন?
এক্সটেনশন শেষ হলো মে 2022।
Stated, my lord, what really had transpired. May I read?
এটা বলেছে this period will be deemed to be excluded. তাহলে কি চলে যাবে? তাহলে
So page 4, paragraph 3.
Page 4, paragraph.
Page 4, paragraph 3. Have your lordships got it, my lord? The background facts stated briefly for appreciating the delay are the following. My lord, we have stated in paragraph 1 that the delay is 52 days. Now, paragraph 3, the background facts stated briefly for appreciating the delay are the following. A judgment and order dated 1st of October 2019 was passed by the learned single judge, in this case, my lord, in GA number. So, because this is a judgment passed by the learned single judge or an application made by the plaintiff decree holder under Order 12, Rule 6 of the Code of Civil Procedure. That application was since allowed and a decree was drawn up and completed by the learned single judge in the original site. So, my lord, that is GA number 121035 of 2018 in CS number so and so. The petitioner and the respondent number 2. Respondent number 2 here is, my lord, the judgment dated number 1.
So you are challenging, basically the judgment under review is the judgment dated 3rd of March 2020.
Yes.
That's right. That's right.
So yes, what do you say? This
With
view of the
regards to
Supreme
with
Court
regards to
judgment?
the review, the condonation of delay, I will not oppose it much. So
Because,
condonation of delay with regards to the review application, I have
that's
something to
different.
say.
Let us condone the delay.
Can be
Because,
condoned.
in view
Even
of
if it be, yes, because of the suo moto extension, that minute. And otherwise, also, if he's saying it's a 52 days delay, they had preferred a, yes,
Uh, when you, Mr. Chakraborty, what was the last date till the extension was granted by the Honorable Supreme Court?
March 2022.
Can you please help me? Huh?
March 2022 minute.
Yes.
She is more abreast. She is better abreast.
Of March 2020 till 28th of February 2022 shall stand excluded.
From March 22, the limitation starts running.
Yes. So they will be getting 30 days.
30 days.
30 days.
April onwards, we count.
They will have, all persons have a limitation of 90 days from their short extent. Notwithstanding the actual variance of period, it will be 90 days.
Yes, so 90 days they will be getting after
Yes.
that. So March, April,
May.
end of May.
Yes.
So they are filed in July. So June and July will be the only.
That is the reason I am not opposing to it, because it is otherwise not very long.
Though the registry pointed out
Just a little constraint, my lord. My learned junior says that only one day before the listing, he gets to know. Well, then it becomes, since I live in another city, well, if a date can be fixed, my lord, any time, subject to my lord's.
The difficulty is that my brother is
Availability
also
of the
part of a
bench.
very important easy bench. So
I appreciate, my lord. Any
Correct,
Friday or any other day at any time, 2 p.m.
একদিন আগে একটুখানি দু তিন দিন আগে how much time you want prior to listing?
May it appear in the month of July, my lord, because we have a long vacation in the month of June, my lord, that is the only time we can possibly, my lord, go for a holiday.
ডেটটা আমরা পুরোই দেবো, দেখিয়ে দেবো 2-3 দিন আগে।
Let's list this matter in the month of July.
On a Friday, my lord.
Let us see what happens, because sometimes some larger banks
বলুন না
they
ডেটটা
have
কত?
the month of July any day, but 2-3 days
আপনার
prior
তো
to
ছুটি
that,
থাকবে, আপনি থাকবেন ইন্ডিয়াতে?
সেটাই, my lord, I am being told that the learned single judge, my lord, who is
Has fixed the
seized of, my lord, the section
execution.
47 and the execution matter, she has fixed the matter on 7th of July.
11th
The
of
learned single judge, her lordship, her ladyship, and my lord, normally,
so it has to be prior to that.
as your lordship pleases.
That would be our prayer, my lord.
এটা করে দিন after reopening of this court after summer vacation করে দিন the date will
First week of July,
it says 7th it is fixed.
7th, 7th is Tuesday.
Yes, that's the problem.
So if it is possible, 3rd July, it's a Friday, my lord, 1st July is
The
Wednesday.
reopening that we will consider in the 3rd or 4th week, we will consider.
I might
Will be available from when?
from the month of July, I shall be available.
So entire June you will not be
Well,
there.
I am not very sure as to when shall I go and when shall I return. So, my lord,
Month of July.
July, grateful. Thank you.
Though I don't think this will be a predicament, because the respondent number 1 in the execution proceedings, my lord, the one defendant has paid his part of the decretal sum.
What is the dispute?
My lord, the dispute is, may I just tell your lordship in a nutshell? My lord, the dispute is that my learned friend's client, my lord, there was a company called Vacation Exotica, used to deal with travel and tour business. Now, my learned friend represents a Maharatna company called Bama Lorry Limited, based in Kolkata. So, my lord, this Bama Lorry Limited wanted to acquire the assets and also, my lord, the liabilities of Vacation Exotica. Now, my lord, I am shown as a guarantor in that I am not both myself and the judgment debtor number 1, they were directors of Vacation Exotica. But when the agreement was entered into and between Vacation Exotica and Bamalori, I was shown as a guarantor only. And the judgment debtor number 1 and a host of other persons, they were absorbed by Bamalori Limited as their employees. So they went into gainful employment under Bamalori Limited. So, my lord, the agreement said that the Bamalori Limited will get the accounts audited thoroughly to their satisfaction. And it was done. And so then an amount was, then subsequently they came back and said that some amount, my lord, were hidden and were not reflected on the records of on the books of the company. So in such circumstances, which according to us, my lord, the defendant number 2, which is strongly disputable. But at this stage, my lord, let me just say the disputable but the court cases, so far as this matter is concerned, was handled by the judgment debtor number 1, who was the defendant number 1. So, my lord, a suit was filed before instituted in this honorable court. And in the plaint, they referred that before the filing institution of the suit, judgment in number one, defendant number two, and two other persons. One is the mother of defendant number one, who was not a party to the agreement. The other is one Basant Lal Jain, who was also not a party to the agreement. They also stood guarantors, and they wrote a letter that they will together pay up the demand, the financial demand of Bamalore Limited. So, on that basis, an application under Order 12 Rule 6 was made. It was the decree was passed, drawn up, and it was carried in appeal. My Lord Justice Bhattacharya, my Lord, sitting with my Lord Justice Shonjeev Banerjee, as his name then was, my Lords were pleased to uphold the decree, against which we preferred a civil specially petition, which was summarily dismissed. So, my Lord, I would tell you, Lordships, my Lords know the law. My Lord, because of doctrine of margin, I still can come back to your Lordship.
If it is because there are line of decisions which says
my Lords,
the doctrine of margin.
absolutely. My Lords will kindly consider those aspects on the next date of the hearing. I am grateful.
I'm deeply obliged.